There are some unique ethical obligations that we want to make sure everyone is aware of, and that we just start off from the very beginning and build in those systems and practices so that you don't find yourself in hot water down the road. And so there were a bunch of topics. Some will probably have more to say on than others, but some are things that just as lawyers we ought to know about. So I have a little bit of a checklist that the speakers helped us put together, and we'll kind of run through those topics. So there are some state bar topics, and I don't know if you want to wait for Jerry or we can get going on those simple things like MCLE compliance and how does that work in terms of your license. And so I don't know if that's something that you can...
That's fine. I can start with that. You are required to take, I believe it's 25 units of MCLE with at least 5 or 6 in ethics, plus 1 in substance abuse and prevention, and 1 in diversity every 3 years? Every 3 years. And you're, it's regulated, when you must complete these is regulated by your last name. Like A through K will be one group, and the next will be J, and so forth. There have been, in the last 3 years, the State Bar has begun auditing the MCLE, and the basic thing that you need to know is that if you have not actually completed and you don't have the paperwork to prove that you have completed your units, do not sign under penalty of perjury that you have and file it with the bar. Tell them the truth. I have not completed it, and I will pay the penalty. I'll pay $50 or $75, and I will complete it, because they are now prosecuting. They are auditing, and the percentage of audits that they've done is set to increase every year. What percentage are they auditing now, Jim?
Well, when I spoke on the panel, it was 5%. It went to 10% the following year after they found out how many people they could catch. Right. It may be up to 20, I don't know.
Right, and so when they catch you and you have perjured yourself because you can't prove that you took 24 units, this is a serious disciplinary proceeding. And you know, it's tantamount to moral turpitude, because you didn't tell the truth, not that you missed a class. So just be really careful that you maintain all of your records, that it's good to space out your MCLE and, do, 5 or 6 every year. Whatever you have to do to just keep it in order, and know that by the time your compliance date comes up, which is always, I think around the 1st of February, that you've got your units and that's it. They're serious about this.
Okay, so another topic that we wanted to talk about was sort of the refund of unearned fees. Is that another area where the State Bar can find you if you have not done things properly?
Yeah, and this is one of the more difficult ones. Rule of professional conduct requires that when the representation is over, that you refund to the client any unearned fees. If you're holding money in trust, or if you don't have it in trust, but you charge them more than you incurred, it's an affirmative obligation to return the money. What will happen in a percentage of cases is the clients will complain you overcharged them. And now the question of what's a fee dispute and what is a disciplinary unearned fee sometimes get confused. And so the practical thing that we advise in our law firm, remember now we're going to talking about sending out regular bills, you pretty much have a presumption on your side that whatever that last bill was anything over that, pay it back to the client. Anything the client complains about in there, you now have a business decision. I'm going to connect a few dots here. You will have disagreements with some of your clients over the amount of the bill. In most cases, we recommend to our clients who are attorneys, treat it as a business dispute and not as a moral crusade. Treat it as a moral crusade. I can almost guarantee you it will get out of hand, it will become a fee arbitration matter, a state bar ethics complaint, bad write-ups on Yelp and Avvo. On the other hand, if you treat it as a business dispute, just think of any time you've had a problem with a business where either you thought you were overcharged or they shortchanged you or they gave you a crappy product. You went back in, you expected somebody to talk to you about it, you expected some resolution. So that's kind of your parameters there. If the client asks for an accounting, and this can happen sometimes, you did a case for a flat fee, or the client wants to know what you did, because maybe you never did get around to sending these monthly bills out. Then you have an ethics obligation to account for it, if it's an hourly or a flat fee in which you didn't complete the case. And you have a civil penalty. Remember, Lindsay said it's not an ethics offense to not have a written fee agreement. It's not an ethics offense if you don't respond immediately to a request for an accounting, but if you don't respond within the statutory time, the client gets to declare the fee agreement unenforceable, and now you're back having a reasonable fee dispute with your client. On the other hand, ask yourself, how would you feel if you went to the bank and they said, well, you've got $32,000 in the bank, and you say, yeah, but I want to see my checks and my income. Well, you got $32,000 in the bank. That's it. Remember, the clients don't see what we're doing, and then we give them these big bills. So we've got to be transparent.
So we talked a little bit earlier about the importance of communicating with clients around bills, but are there other areas, status of case or other areas where you need to be communicating with client and failure to do so is going to land you in some hot water? For example, settlement offers or,
Yeah.
All right.
Yeah.
The first overarching general rule is any significant development in the case, you have to tell the client about. There are specifics like written settlement offers. There are practical ones like any settlement offer. But what we see constantly is complaints against lawyers by clients who don't know what the lawyer is doing. And certainly the monthly bill is important. Certainly sending copies of things is important. Sometimes an event occurs in the case. Big motion granted, big motion lost. Case set for trial, deposition coming up. Deposition transcript comes in and has to be proofed out by the client. To talk to the client. What you have to think about, client by client, case by case, is what's this case about? What does this look like from the client's standpoint? And what do I have to do to make sure the client is informed? End of the day, this is the client's case, it's not yours, it's not mine. This is the client's divorce, this is the client's articles of incorporation, this is the client's probate. And then our clients, the fact that I've told you something doesn't mean that you have absorbed it. It probably means you absorbed it for a minute or two. Come back and tell them again. Tell them a third time. Call them up and make sure they understand what's happening. Big cases that are of extreme significance to clients, they sometimes get really, really difficult for the client to make a decision. If a settlement offer of a case you and the client discussed it being worth between $1 million and $1.3 million, and they've just been offered $950,000, and they can't make up their mind, and time to do something is approaching. You write the will and they never show up to sign it. Because if I have to come in my lawyer's office and sign my will, I have to confront my mortality. And maybe right after I saw my lawyer, and this is really important, maybe my mother took sick and I'm just totally distracted. I can't be bothered with this stupid lawsuit. I gotta go sit with mom. So all kinds of things going on. So you have to stay in touch with the client and as best as we can to make sure our clients understand what's happening in their case and what they have to decide.
Yeah, I would really second that. You're gonna run into clients that may need an explanation even of certain things in the case more than once. Not just a reminder, but an explanation, because it just may not get it. I see that happen rarely, but I sometimes have a client who will come back to me more than twice to explain the same thing again. The other thing that you need to remember to do, you've all been in law school now for some time, and perhaps working in a law firm for some time. Try to phrase things in ways that your clients can understand when you're talking to them. You want them to be able to clearly know what you're talking about, so don't use jargon. The other thing that I have found is if you're talking to a client and there's an ethical problem that comes up, and the one that I've had happen more than once is a client say to me, well, I'll just tell them I didn't know that, or I didn't say that. That's tough. You know what you really got to say, or what you want to say to them is, I can't allow you to lie. I can't allow you to lie, and I have to tell, or something like that. Well, if you think about it, that client is probably just reacting in the moment, so you hope. So what you want to do is talk to them about the consequences of what that could be, so that it takes some of the onus off them, allows them to kind of preserve their dignity and say, you know, the thing that I say is that never works. I've never seen that work. There are people on the other side that know what the truth is. They're going to say it, and you're going to really damage your credibility before a fact finder, perhaps, by doing that. And that actually generally works. And I think it's not really because they were going to lie, but because it allows them to agree with me on an issue and calm down, because that was a reaction to knowing that they had some responsibility in what was happening to them. They don't want to take that responsibility. So I think that works well.
Yeah, I think that is a very astute observation, and you're giving someone an opportunity to back off. Another good thing to do is don't force them to make a decision right now. Give them enough time that they can think about it, and talk about it again the next day. Somehow when you sleep on something, you see so much more. And we also have to remember that in some fields, some areas of law, the clients are just incredibly emotionally involved, and they're so upset in the situation. And this happens in family law, it happens in estate planning and probate, elder law, conservatorship, all those
Lawyer
issues.
discipline.
Lawyer discipline, and you get a letter from the state bar and then talk to me. You'll be upset. And so we have to, as lawyers, we have to recognize when our clients are just really, they're just beside themselves. They can't think straight. You have to help them calm down. And then you have to give them time to be rational.
By the way, one of the things I've come late in my career to understand is the first meeting with the client, you come in, first of all, the basics is get rid of distractions, turn off your phone. I actually make a show of it. I tell my secretary, hold my calls. I mean, my phone's already on Do Not Disturb, but I'm letting the client know this is important. Then everything is cleared off my desk. And then I look at you and say, what brings you here? And then I listen. You tell your story your way until you're done. And until you do that, you can't pay attention to anything I say anyhow. And you probably come in with the story you have rehearsed. all right? And it's either you feel guilty because you've done something wrong, or you don't feel guilty, but you think the state bar thinks you've done something wrong. Well, somebody walks in the door, they've been married 30 years, and they've just been hit with divorce papers they didn't see coming. They have a lot of emotion here. And they gotta tell their story first. Now we can begin to take notes, make lists of things to do. What Lindsay just said is important. You might have had a pretrial motion granted that just knocked off a third of the client's case. So first of all, you're upset. Second of all, now you've got to sit down and tell the client. And third, now they're really upset because their world has just ended. And it will take time for them to process the bad news and for you to be able to talk to them. So many times you just see that glazed over look on the client, or you're trying to discuss something on the phone and they just seem like they're being just stubborn. Well, you know what, maybe they just had it for the day. And it's time to say, look, like she said, let's continue this conversation tomorrow. Be really aware. That's the flip side of communication, is listening. It's not just talking at your client. What are they doing? What are they going through? And then sometimes formulating the strategy on how to approach the client on issues that if you push, they'll just dig in and fight, like me, or like you. And they may be able to see it a week from now, and they may be able to see it if you present it a certain way.
So that, I shared with you over the phone a situation from when I was practicing where it seemed like the attorney's interests and the client's interests might start to diverge. So, for example, when I was at a firm that handled contingency fee cases and got to summary judgment and realized there's probably not enough here to move forward, but the client, she
Right.
wanted her day in court, and the attorney was going to have to front all those fees and, front the litigation costs. And that created some interesting conflicts for me as a new attorney and trying to understand how to navigate through all of that. And so I guess what guidance do you offer when those moments do come up where the client, the lawyer may be taking a reasonable, rational position, the client has no interest in that because it's a very emotional situation for them?
So we start off in the fee agreement by don't promise any results. And in the consultation, don't give the client room to think that you're promising, oh, I can handle this. Oh my God, this is a $500,000
Yeah,
case.
what the kid never, ever
or
talk about the value.
Your
of
employer can't do that. We'll sue them. Okay, and then you get downfield and you can't carry on the promise. The second is, in contingency cases especially, do not put in your fee agreement that you will advance costs. But put in an indirect clause in there that says if you advance any costs, they're reimbursable. And the reason for that is downstream where the client wants to go full throttle ahead and you think it's time to either accept a settlement or it's time to bail out, you may take the option of looking at the client and saying, well, I'm willing to try your case, but you're going to have to front the next $50,000 worth of costs to do so. A lot of times the issue you've described comes up in the contingency fee where the settlement's pretty good and the client thinks they can do better at trial. And you can see the pros and cons of it, and so I have my clients prepare what's called the double budget. Here is the current offer on the table. Here's how it will be dispersed. Here's how much money will be in your pocket. Now, if we go to trial, in order to get that much money in your pocket, here's what we have to recover, and it has to be much more because we have experts, we have trial prep, we have whatever it is. And sometimes that's the sobering document, but the client can't read it for a day or two or three because they're on the warpath. That in turn is try to set your cases up so you're not making these kind of decisions with an hour's notice. Back to the communication, we're doing contingency work. I used to send my clients a list of costs incurred. So they weren't surprised. Their $700,000 settlement, there were $75,000 worth of costs they didn't know about until they saw the settlement sheet. And when the settlement offer comes in, they don't say, hey, we got $750 on the table. It's we got an offer of $750 and your net will be, so they don't get the sticker shock of thinking they just settled the $750,000 case and 400 of it is theirs, and where the hell the other 350 go? So those sort of things. But you remember I said something earlier about don't put a restricted withdrawal clause in your fee agreement? That's because under California law, if you reach that point, you can ask the court to let you out of the case, as long as there's enough time for the client to be, to interview other attorneys, not necessarily hire them. If it's a week before trial, you can try the case. If it's 3 months before trial, you can probably get out. If you're in a plaintiff's contingency case, you're probably gonna give up any part of the fee if you're leaving the case because the client won't settle. If the client has just burned the evidence and refuses to acknowledge it, that would be reasonable grounds to get out of the case, and maybe you will get some fee if the client recovers anything. These are high stakes problems, and most problems can be dealt with as long as you remain calm and professional and don't get sucked into the argument, don't get sucked into the client starts accusing you, well, you're selling me out because you just want the money. And well, let's talk about that tomorrow. This is getting a little testy, okay? That's part of what this business is about, is counseling people who are scared and angry. And never forget that. They're scared, they're often angry, they're often involved in legal proceeding that will never make them whole and never make them happy. And there's only so much we can do for them, and the rest is just try and help them get through it.
So, what advice do you have on the front end about choosing your clients wisely?
Yes.
And, with experience, particularly with experience, you can recognize some of those patterns and know some of the red flags. But if you're just starting out, what advice do you offer so that, because obviously, if you get good clients in the pipeline, hopefully you don't have those problems down the road.
If you're new, especially if you're young and new, this case walks in the door, and it's a big case. You go, ooh, cool, I just got $1 million case. Or, gee, it looks like a pretty good case, but the statute of limitations expires in 4 days. Okay? There is a reason. Okay? Unless divine providence has interceded on your behalf, there's a reason these people are in your office at the end. And you'll find out what that is later. So that's a red flag. If they've had previous attorneys, I want a young attorney because you're young and enthusiastic, and that old guy who's representing me just doesn't care about my case. It's not about the money, it's about the principle of the thing. I stuck a line in the syllabus, from that recent popular song. I knew his trouble when he walked in the door. When you get that feeling, even if you can't figure out why, say no. You may not know now, but if you say yes, I promise you within 3 to 6 months, you'll know why you have that feeling in the pit of your stomach that said no. These are just bad news people. They're never worth the effort. And we make a living because, in part, for extracting you from those cases.
I had some clients who were like mental cases and vexatious litigants when I first started practicing. They were really interesting, really charismatic, very dramatic people. But, they were just, you could never make any sense of it, and you could never make it work, and all they're going to do is take your time. So you really have to be careful that you have a client who understands the reality of the situation, and if it's a small case, it's a small case, and what it's really about. Not people who come in, with these wild ideas of, what they're going to do, how much they deserve, or, you know, you could literally have a person with mental problems. Just, I mean, they actually are attracted to litigation. There's a class of people who are, they're like out of Dickens, out of Bleak House. They walk there carrying their papers with them, and they'll plead their case to anyone who will listen. And when you're young, you know, you may not see it, or you may be really sympathetic, you know, and it's really just, you know, you can't be too careful.
So, what if you don't see all the red flags before they come in? It seems like a compelling case. They seem like compelling clients, and you know, you get down the road and you discover you need to disengage. You need to. What are the ethical obligations for how one disengages from a client properly, so that that doesn't invite more trouble and an even longer relationship with that client, because now you're in litigation with them?
You have to give the client adequate notice, which means you have to tell the client that you're getting ready to withdraw, that you want them to get new. Actually, the language I recommend almost all the time is, the attorney-client relationship is not working out and it's time for you to get a new attorney. So that I'm not picking a fight with the client by saying, you know, you're a mental case, I can't stand you anymore.
You're a piece of work.
You're a piece of work, right. Right, you're lying to me too much. And you can't do it at a time that would prejudice the client. For example, answers to 30 interrogatories are due Friday. You're gonna have to do those wrongs. I see this a lot when my client's been prepping the underlying client for depo and realizes, uh-oh, this is gonna be a disaster. Well, if you can't wiggle out of that deposition, you're gonna have to go do it. You're gonna have to finish whatever is in the pipeline in the next X number of days or weeks. Next thing is just like dealing with your 2-year-old throwing a tantrum, is just, you know, set a firm rule and then carry it out. So, I can't imagine parents arguing with 2-year-olds, only because I haven't had a 2-year-old for years. But it's like, you're going to bed at 3. Well, that's the end of the discussion. 3 o'clock, put the kid in the bedroom. Client, I am going to withdraw from your case on June 18th. I will file a motion if you haven't found a new attorney by then, or if you haven't substituted out. Once you put that date down, hold it, and then remind the client every few days, or remember, I'm withdrawing on June 18th. You don't have to justify yourself most of the time. It's just, hey, the attorney-client relationship is not working anymore. And you know it and I know it. This is not the point to get in a finger-pointing, name-calling session. And stay calm and stay professional, because if someone else is going to second-guess the way you withdrew, state bar investigator, trial judge has got a rule on the motion, the people who will look at the file for potential malpractice. I want you to look like the calm, reasonable professional, and not like someone who's as mentally disturbed as the client. I've never seen a long, self-serving rant that helped the attorney. I have had to explain things to plaintiffs' malpractice carriers, plaintiffs' malpractice attorneys and fee arbitrators and state bar investigators. Well, my client got a little upset, and so he went a little bit over the top, and he really shouldn't do that, and he won't do it next time, because I've had a little chat with him in this tone of voice.
So another question that, earlier in the day we talked about some of the advantages that technology brings to starting your own practice, or just kind of the different paradigm for setting up shop, where you don't necessarily need to have a brick and mortar law office. People are working from home, they're meeting clients in Starbucks, their files are stored in the cloud. It seems to me there are various confidentiality concerns. Are there in shared office space? I guess, what guidance can you offer? Are you seeing the state bar, or are there any concerns about, meeting with clients in Starbucks, or, are there issues that might come up, or working in shared spaces that folks should know about to make sure that they're adequately protecting their communications with their clients and client documents.
Well, your basic duty is to maintain client confidentiality. And that's true whether you store your papers in files in your garage or you store them, you know, in the cloud with, you know, a secure storage provider. It's really the same thing, and you just need to know. So, and take some adequate step to, you know, assure that it's not just out in the open. Basic things like, you know, having a filing cabinet system that is not, you know, no one but you can get into the drawers, you or your assistants. If you're sharing office space, segregate your files from anyone else's or from their staff. That's your obligation. When it comes to meeting in a Starbucks, I think that, I mean, you could meet in the park or somewhere where you're not going to be overheard, but it seems that it would be kind of difficult to have privacy and to talk about something openly and frankly sitting in a Starbucks. You'd think everyone on their laptops was taking notes on you. So I would suggest meeting somewhere that, you know, is a little more private, maybe even, you know, a restaurant or coffee shop or somewhere that, you know, where you have a private space. Yeah.
I have something to add to that you talked earlier about having your desk clear so that the client would feel focused, that you were focused on them. But it's also important to remember that even the fact that they are a client of yours they can expect confidentiality with that. So if you meet people in your office, those files need to be put away. So you can't have client files all over the place and then invite a client in to sit at your desk and see those files, because that reveals to them who your clients are.
I've walked through offices and I'm looking at boxes with people's names on them, and sometimes it does not implicate confidentiality, and sometimes it does. I make fun of my colleagues over in the State Bar Prosecutor's Office. I say, you have statutory confidentiality here. I'm sitting here at your desk looking out there and I see the names of 5 people I can now go out and solicit as clients. And talking casework outside of the office. I used to work in a welfare department. The welfare director said, I've given up trying to prevent social workers from talking about their cases in the county cafeteria. I am now asking them simply to use first names. I came down an elevator in a hospital once with a sign that said, we show our patients that we respect their privacy by not talking about them in this elevator. We lawyers have the same thing. We talk shop. We go out with our friends and talk shop. Go out with my wife, who's my law partner, and talk shop. I just have to be careful that we're not talking about your case in front of everybody in Starbucks. And you know, it's funny because I saw the thing on there about, you know, special issues with the cloud. Well, if you're storing your files up there, where are they going? I asked my tech person. You tell me it's in the cloud. Where exactly? Where exactly are my backup files? And used to be in the basement of my tech guy, but at least it was a private basement. Now it's, you know, I know the name of the vendor that he stores it at, how it works. No different than if I give my files to Iron Mountain. You know, they're reputable, but where are these boxes? So yeah, confidentiality, that was the main issue, wasn't it?
Yeah. Are there any other kind of new trends that you're noticing with the state bar? Lindsay talked earlier about the audits, about CLE. Are there other trends that we're noticing now, particularly around solo and small firm practices, that just kind of helpful to get on people's radar screens?
Communication. See, the problem in the big firms, they have lots of bureaucrats to do everything that needs to be done. It's real easy in solo practice to put off something. If you calendared a deadline, you know, you have so it's the failure to communicate. The client saying you don't communicate. It's the clients who are upset with their settlements. Now you have to go back and demonstrate that the client consented to the settlement, and that here's where the money went, and yes, the settlement check went into the trust account, and here's where the money went out, and we accounted for the liens. So those sort of things. I'm seeing, and this comes in your field, an uptick in the number of lawyers who call me up and say, oh my God, I have this wrongful termination case going, and my client just walked in the door with a CD of a secret. Didn't tell his boss he was recording it. Boy, wait till you hear what the boss said. Or just downloaded 100 documents from the boss's computer. Or flip it around. You know, the boss who comes in and says, I don't know, my boss got my Yahoo password.
Yeah. Last week that went viral. It happened 15 times. Just happens like that.
Coming over on BART today on one of our listservs, they're talking about this issue. It's, oh my God, my client, it's so, the complaint will come in when she finds out that your client has recorded the boss. And then, what were my obligations, what were your obligations as the plaintiff's attorney from that point forward? Do you have an obligation to inform her? Do you have an obligation to keep it secret? Did your client honestly admit it when asked at the deposition? What do you do with the CD? All these kinds of issues. What else? Complaints from opposing counsel that you lied to them, or that you suppressed evidence. We see a steady number of complaints in the estate planning field where the person who got cut out of the will thinks you're at fault, or where the executor of the estate, you're the attorney for the executor, and the executor steals some money, and somebody thinks you're responsible for it. Discovery sanctions. Common mistake. Don't ever threaten somebody with a state bar complaint. It's called extortion, and it's also a violation of the rules. And then the unethical person you just threatened with a state bar complaint, they go, oh my God, he threatened me with a state bar complaint. Go punish him. What are the other?
It seems like enough.
It revolves around communication with the client. If you can keep a relationship with the client and be the client's counselor, advisor, and just listen sometimes, that solves a lot of problems. And it's the people who don't communicate with their clients, and then you realize, well, oh, I didn't get that consent to multiple representation from one client out of a mass tort of 200 people. What happens now that we're ready to settle this? You know, it's...
Multiple clients, thank you.
Multiple clients is
anytime you are representing more than one client at a time, a group of carload in an accident, heirs in an estate, you're not going to be doing mass torts. I should not think at brand new level, but maybe 5 people walk in the door and they have a common thing.
Two partners, two business partners.
Right. Yeah, the paradigm is the three people who come in the door and tell you about the four partners who are setting up a new business and they want you to set it up for them, and who's your client. Anytime you have more than one client or more than one person in the room is not necessarily a conflict of interest, but if you're going to represent more than one person at a time, even in a non-conflict setting, we strongly recommend you get a joint client consent where you have explained the basics of what it is to advise two people rather than one. And it's difficult. I have only once in my career seen a joint client consent or a conflict consent that wasn't identical to everybody. It should be the same document sent out to 1, 2, 3 people, and they all sign it or return it. Don't put it in the fee agreement. It's a separate standalone document.
I can tell you in my practice where I see it is that the employer will be sued and the HR director will be sued and the supervisor will be sued. And you've got 3 people who may be, well, probably one person, the supervisor, who's going to be having fingers pointed at them. So that really is one of the areas that I see. And I have a letter, I mean, I really kind of couch it as a letter, which is common to all parties, and it talks about the fact that I don't see a conflict. We've discussed it. They don't see a conflict yet, but we all agree to tell each other the minute we believe there is a conflict. Then sometimes what you build into that is who you will continue to represent if there is a conflict. Those are all very practical things that need to be put into one of those documents so that if something happens, and it almost never does, but if something happens, we'll have laid out for everyone and for yourself what will happen.
The rules of professional conduct do not tell us what to do when you are subject to 2 rules that give you conflicting domains. So, if you don't have this done and a conflict arises among your 2, 3, 4 clients, you basically are going to have to withdraw from everybody. Whereas California will at least recognize most of the time, say you've got my kind of practice where I advise an attorney, there's a state bar complaint against the attorney and the associate. So I agree to represent both. I beat up on the attorney to pay the whole bill and take responsibility for what the associate does. But the attorney-client, I have a separate agreement with the associate. It says, I'm going to do this, but Joe's going to pay the freight. But it also says, if their conflict does develop, I will continue to represent Joe, and everything up to that point is not secret between the 2 of you. Everything after that is. And you'll have to go get your new attorney. Oh, just before I forget, off the wall, just because it's in the public record, it doesn't mean it's not confidential. There can be things out there hiding in plain sight, nobody knows where they are or what they mean. It doesn't give you the right to go blab about it, if it's a client secret.
Right. Another thing that we forgot to mention is the need to keep a conflicts list. And it won't seem real important to you at first, especially if you're starting out solo. You won't have that much history, but you have to begin accumulating it from the very first case. So you want to keep a list that for every case that you handle, what is your client's name? Who's the attorney on the other side?
Who's the defendant?
Who is the defendant?
Or the party.
Who is the other party? Are there other people involved whose involvement is significant? And then, before you take a new client, you're going to have to go back and check that the new client, the representation of the new client would not be a conflict with the one that you already took. And I guess at some point, you will have past representations. And then you will have to make a determination of whether or not there is a substantial relationship under the conflict of interest rules.
I have a question.
And then we have the whole
Okay.
30 seconds.
Just a real quick question. What about people who just call you and you have just a short telephone consultation so that you can refer them on?
Oh, you tell them about that.
The specific answer is, if you don't engage in an attorney-client relationship, most of the time, then it's a so-called preliminary consultation. It's not a true conflict, and if someone alleges it's a conflict, it's that person's job to prove they gave you confidential information. Having said that, and this is really funny. One day, Lindsay and I were in the office, and we each get out of the office about the same time to tell about this new client we've signed up. Make a longer story short, it was a law firm splitting up, and she got partner A and I got partner B. And of course, they're not on the conflict list, because we're just talking to them. And so of course
we had to give them both up.
But there's a psychological thing, I'm not entirely sure what it means, but I will share it with everybody, and she and I have talked about it, is just in the course of the short conversation, I came to believe the people I spoke to were wrong and the people she spoke to were scumbags. And she came to the exact opposite conclusion. The people she talked to were right, and the people I talked to were scumbags. And there's something about the way we look at our cases, deal with people, and become advocates.
Yeah, we want to sympathize with our clients.
I think we'll need to leave it there because we,
I just have a quick question on the conflicts list. How do you maintain a conflicts list on transactional matters where you may not even have negotiated against the other contracting party? You just drafted the agreement and they signed it. I mean, do you consider that an adversarial position?
Yeah, no, I think you still have to do it, even if it wasn't in litigation, because you have to make sure that, if you represented one party to a contract, that you don't, have a later engagement that has a relationship to that contract, on the opposite side.
No, the people you advise are your clients. You
Right,
always
no, I
want to
understand that
keep
part.
track of their names, so
But I
that
don't
you
have to keep track of the adversary, the other side.
I'm not understanding who the other people are.
In litigation, you track both defendants and
Right.
plaintiffs and in your litigation matters as far as conflicts and what parties are involved and stuff. But in transactional work, what do you track? Do you just have to worry about?
It depends what the transaction is. If I'm representing the landlord in a transaction with a tenant, I would flag the tenant as the opposing party on my conflict list. If I'm representing 4 people putting together a business, the 4 people in the business will all be my clients. There will be no adversaries. If I'm representing a testator writing a will, maybe there are no adverse parties. I give everything to my wife, and if we're both gone, everything goes to our 3 lovely children. If I cut 2 children out of the will, I better make a note that those 2 children are adverse, so that 5-10 years from now, we don't take on the 2 children as clients in a will contest.
Okay.
So it's a practical thing. I look at it in 4 categories. Who's my client? Who's allied with us? Who's the other side and allied with them? And then who are the other people in here who are significant, but I can't figure out whether they're them or us? And the conflict list doesn't tell me if I have a conflict. The conflict list tells me that I've got to go look at that previous file and figure it out. So it's tracking names and knowing that when a name pops up, it has, we've either represented them or been adverse to them at some point in the past, and we better make sure the present case does not put us adverse to our former client. That's basically the question.
So I think we need to wrap that up there. We have one last segment, which I think will be a really fun way to end the day after talking about some heavier issues, this final segment will be a great way to send us off into our practices. So we just need a minute or two for you to do your paperwork, and we'll shift the line above here, and then we'll get started. Thank you.